Your Honor. We're on the record.
Thank you very much. Good afternoon. The Appellate Court for the State of Connecticut is now back in session. For the record, we are conducting this hearing virtually via Teams and are live streaming this hearing on YouTube. Counsel are advised, to the extent that there is statutorily protected parties and or information here, that you must take care not to reveal said information. I would ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, and finally counsel for the appellee. I am Judge Elgo.
Judge Alexander.
And Judge Sheldon.
Good afternoon, Your Honors. Naomi Fetterman on behalf of the petitioner appellant, Mr. Kevin Marshall.
Mitchell Brody, Assistant State's Attorney for the State of Connecticut.
Thank you very much. So counsel, prior to this argument, you received procedural instructions for this hearing. Are there any questions before we begin?
No, Your Honor.
No.
All right, thank you. And for the record, I note that I can hear and see everyone. Please let us know if in the course of your argument you are experiencing any difficulties hearing or seeing the participants. If you should lose your video capability, please log out and log back in. That hopefully will correct any problems that you are experiencing. We will take a pause in the proceedings in that event. All participants must keep their video on and remain in view out of respect for the process and the other participants. Thank you, Attorney Brody. And all participants are also asked to keep your microphones off and muted when you are not speaking. The judges will raise their hand if they have a question, though if you do not happen to see them, I will try to draw your attention to them. We will interrupt. Please keep in mind that while this is a virtual hearing, all participants are expected to conduct themselves with the same formality and respect for the process as you would in our courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal and should advise me before you begin how much, if any, time is requested. Judge Alexander has graciously agreed to be our timekeeper and will give you a warning. I believe it's a 2-minute warning. Correct, counsel? Correct, Judge Alexander, and when your time is up. So we will now hear the matter of Marshall versus Commissioner, and Attorney Fetterman, you may proceed.
Thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal, please. At issue in Mr. Marshall's case is the propriety of the habeas court's dismissal of Mr. Marshall's pro se petition, even though counsel had been appointed to represent Mr. Marshall in the scheduling order that had been entered into by counsel for the petitioner, and the respondent did not call for the filing of an amended petition until November of 2021. However, the habeas court sua sponte issued an order stating that it would pursue a dismissal based on 2329 for failure to state a claim upon which relief could be granted, or alternatively lack of the habeas court's jurisdiction. At the hearing before the court, petitioner's counsel advised the court that he believed Mr. Marshall did in fact have colorable claims that would not be governed by this court's decision in Farrar. In fact, the petitioner's counsel explicitly advised the habeas court that he would not be pursuing a claim that would be foreclosed by Farrar, but he did believe that Mr. Marshall may have 2 other viable claims, but had not done the entirety of the research and the investigation necessary to raise those claims at that time. In response, however, the habeas court adjudged the merits of Mr. Marshall's pro se petition only and therefore dismissed the petition. As we've argued in our principal brief, once counsel has been appointed to represent a petitioner, the counsel must be permitted to effectuate his statutory and constitutional mandate to provide effective assistance, and must be permitted to either file an amended petition, or if upon review, counsel is mandated pursuant to the practice book to file a motion to withdraw. Certainly, we do not expect counsel to pursue frivolous grounds for the habeas petition. Oh, Judge Sheldon?
Judge Sheldon, you are mute. Oh, there you are.
I'm
Good.
not muted now, I think. My question to you is this. In the event that this court decides that this matter was properly dismissed for failure to state a cognizable claim by virtue of the fact that no liberty interest was pleaded to have been violated, is there anything that would stop him from making the very claim you're talking about in a different habeas action?
The
Would
only,
he in any way be precluded from going forward as a result of what happened here in a future action that does exactly the same thing as he tried to do by way of an amendment?
the only scenario I can envision, which may be a risk in Mr. Marshall's case, is if he's no longer in custody. So if he's no longer in custody, he cannot, by way of a petition for writ of habeas corpus, contest any of the convictions or the sentences. And right now, Mr. Marshall is not incarcerated. He is under supervision. But I don't know the specifics of the sentence and how long that would be in effect. And, oh, I apologize.
No apologies necessary. He's under supervision, but is it a parole supervision?
Unfortunately, I cannot recall, because I know there were several sentences at play, whether he is right now specifically supervised by parole or probation.
Doesn't that matter? In other words, he's still in custody, is he not? If he's he's in the custody of the Commissioner of Correction when he's on parole, is he not?
Oh, yes, Your Honor.
Really?
No, I'm sorry. What I was saying is if his sentence were to expire prior to being able to file an amended or a new habeas petition, then he would no longer be in custody.
For sure, you have no reason to get out because he's out.
He's out, but is certainly, as this court knows, habeas petitions are used to contest convictions themselves, which would remain on his record. So it's not that he would necessarily lose an interest he has in analyzing the issues that he wants to pursue. He just wouldn't have a mechanism to do so because he would no longer be in custody. And of course,
if I hear you right, if he's in custody, there's nothing about losing this on the ground of subject matter jurisdiction, which would disenable him, in your view, from filing what amounts to the identical claim in a new habeas.
Practically speaking, no, but that doesn't change the erroneous nature of the habeas court's determination that it can dismiss a pro se petition pursuant to 2329 once counsel's been appointed. So I think the question before, so as a practical solution, would he be able to file another habeas petition? I would agree with Your Honor, he could. From the legal question presented, which is, can the habeas court properly pursue this course of action? Especially noting that the implementation, what we see with the Supreme Court in Gilchrist, is we're trying to expedite petitions. And right now, we're all here for Mr. Marshall's appeal. And then if it gets dismissed or denied, for Mr. Marshall to file a subsequent habeas petition and merely start the process over again, as opposed to permitting counsel to file either an amended petition with cognizable claims or say to the court, there's no non-frivolous grounds to pursue. That certainly seems to subvert what this court and the legislature was attempting to accomplish with all the habeas amendments. So it is not, as Your Honor notes, that Mr. Marshall would necessarily be without recourse, but that doesn't address the reasoning and the result that the habeas court employed in this case. In this case, you know, as I've referenced in Gilchrist, this case, that question is answered in Gilchrist. What the Connecticut Supreme Court says in Gilchrist is we recognize the practice book, specifically 2329 says the court can take action at any time. But at any time means when the rule becomes operative. 2329 clearly comes after the appointment of counsel, which is 2326. And again, in Gilchrist, what the court says is we appoint counsel so that counsel can cure any potential deficiencies in the petition. We recognize these are pro se petitioners. We say look with an eye toward leniency, allow those borderline cases to proceed, appoint counsel, and then counsel takes up the mantle and either, again, files an amended petition curing those deficiencies, or pursuant to the practice book, pursuant to candor to the tribunal, counsel is mandated to advise the court that there are no non-frivolous grounds to pursue the petition. But what the habeas court cannot do is it cannot prohibit appointed counsel from filing an amended petition asserting claims that might provide the petitioner, or that would provide the petitioner with cognizable grounds for relief, and that would invoke the habeas court's jurisdiction. And again, a scheduling order had been entered into, which was accepted by the court, calling for an amended petition to be filed by November of 2021. This appeal will probably be decided before November of 2021. So when we have a scheduling order that's entered into and there's a date for the amended petition, then that has to be permitted to be filed before the court can, as this court said in Kelsey, wade, albeit primarily, into the good cause to have a trial. This would be a very different argument if an amended petition had been filed and I apologize, Judge Elgo.
No, that's all right. I'm sorry. Could you elucidate the meaning of curing deficiencies as is meant by those provisions? And how is that encompassed here?
I would think at the most basic level, it is ensuring that there are cognizable claims. What we see in Mr. Marshall's pro se petition, I'm sure this court has seen, and Attorney Brody has seen in many pro se petitions, there's cite case law that might not be applicable. They raise claims that they might truly not be allowed to have relief on. But since those claims have passed enough muster that the petition's been allowed to proceed, then counsel must step in and raise only those colorable claims that could in fact provide the petitioner with relief. So I would think the simplest answer is curing potential deficiencies means presenting the habeas court with a petition that can be ruled on, and the effect of that ruling would be, if in the petitioner's favor, would be to provide the petitioner with relief. So when we say deficiencies, I would cannot imagine a situation where the most basic level would be to ensure that the habeas court has jurisdiction over the petitioner's claims, and that those are legally cognizable claims. Does that answer your Honor's question?
Well, I guess my question is, can you, by deficiencies, does that include asserting a whole new different claim, essentially, as opposed to perhaps fixing, certain specifics with respect to how the claim as presented was presented? Do you understand what I'm saying?
Of course, I understand your Honor's inquiry, and I would say that Gilchrist, which has to be considered in conjunction with the broader Sixth Amendment standards for what we expect of counsel, has to be, as Attorney Stone has said in this case, reviewing Mr. Marshall's file and seeing if there are grounds that can be raised by way of habeas petition to limit counsel to what the pro se petitioner has alleged. At best, you're seeing a situation that Chronic brings up. You have a formal appointment of counsel that does not satisfy the constitutional requirements. So I do think in curing potential deficiencies, there has to be an investigation into the specifics of that petitioner's case and seeing what the cognizable claims are there. To expect pro se petitioners to identify sentencing issues and probation and parole issues, much less issues that are underlying criminal trials, that's just simply an impractical approach. And I don't, I'm sorry, Judge Sheldon. Oh, I'm sorry, you're muted.
I'll apologize for that. This was a challenge to the sentence, not to the conviction, correct?
I believe it was
the original one. So if a deficiency is to be corrected, I guess it's sort of following form to Judge Elgo here. If a deficiency is to be corrected, and we're to mean a deficiency in that which has already been pleaded, then it doesn't make a lot of sense to jump from a challenge to the sentence to a challenge to the underlying conviction, at least not in this sort of double jeopardy challenge. It'd be different if it was a double jeopardy challenge that went to an improper second trial where there was no manifest necessity for mistrial. That would be different. This here is something different. This is saying, in essence, the sentence is wrong because it was allowed to exceed the maximum ostensibly or allegedly available. So is that curing a deficiency to say something that challenges his custody, albeit based upon a judgment of conviction, based on a finding of guilty, if you will, as opposed to the impropriety or alleged impropriety of the sentence?
Sure. Well, what I'd like to just say briefly is I don't want to neglect Attorney Stona's representation that he thought there could be a potential ineffective assistance claim about the way the convictions and the sentences were structured. However, all we know from that is what Attorney Stona represented at that very brief hearing. To respond to Your Honor's question, I cite to the language in Gilchrist as being dispositive at the time at which 2329 becomes operative. But I think, again, we have to look at what we expect from counsel once counsel is appointed. And specifically in habeas cases, that would be the filing of an amended petition. So while Gilchrist, oh, yes, Your Honor.
2 minutes, too.
Thank you.
Counsel was appointed to represent him on something which was clear enough to be a double jeopardy challenge to his sentence. And so if he was going to cure a deficiency, how could a deficiency with respect to sentence be a deficiency with respect to the underlying conviction, where it's this form of double jeopardy we're talking about? That's really the question I've got.
Yes, and I apologize, Your Honor, because my argument was perhaps not clear. Gilchrist, with the curing of potential deficiencies, is the time at which counsel becomes appointed. But when we're speaking of counsel's ability to amend the petition to go beyond the arguments raised in the pro se petition, that is tethered to the right to effective assistance of counsel in the broader context that we've raised in our brief. Due process of law, the right to be heard by counsel, and the ability to have counsel amend the pro se petition. Otherwise, that is merely an appointment in form only and not in substance, which this court and the Supreme Court has said is inadequate to fulfill counsel's mandate. So once counsel has been appointed, counsel must be able to effectuate the constitutional mandate. And if counsel is restricted to only those claims that the pro se petitioner has raised and is unable to amend the petition, which would include amending with the addition of non-frivolous cognizable claims, that's what counsel is appointed for. So again, if you adopt the habeas court's reasoning and you say that the counsel can only come in and cure potential deficiencies with the pro se petition without being allowed to go beyond the scope of the pro se petition, that's not permitting counsel to act as counsel and to provide effective assistance. So although Gilchrist uses the language to cure any potential deficiency, which I do think is important, once we have the triggering of the appointment of counsel, we have everything that's attendant with that appointment, which would be the filing of an amended petition. And
Your time is up for this part.
thank you, Your Honor.
You're welcome.
Thank you, Attorney Fredman. All right, Attorney Brody.
So I wanted to begin with clarifying some factual matters, which I think at least factually undermine what counsel is trying to do, my friend here, which is trying to merge the right to counsel with subject matter jurisdiction. I mean, I think the obvious point is that the right to counsel applies when there is subject matter, when the court has obviously subject matter jurisdiction over the petition. But I just wanted to, counsel is framing this as if you have a habeas petition from a pro se petitioner, and that somehow, in this case, counsel had no ability to file an amended petition in order to raise cognizable claims. So I want to point out something. Counsel was appointed after the firm was appointed after the Farrar case, okay? So he had 8 months. That firm and Stonaha had 8 months between his representation when he knew the claim in the habeas petition was not cognizable to amend the petition to file a cognizable claim. He didn't do that. Then what happened was Judge Newsom first sent the notice that he was going to dismiss the case. And then the day after he agreed to the scheduling order, then he had, when he knew that the time was running, he had 5 weeks to file another amended petition with another putting in place of the claim that was not cognizable and with respect to which the court had no jurisdiction. He had time to file an amended petition. Judge Sheldon. You're
There I go.
muted, sir.
Yeah, I know. Now I think, right? Can you hear me?
Yes.
It's been my experience that when the court says we're going to hold a hearing on subject matter jurisdiction, and somebody comes in and says, oh, but we want to amend, the court says, no, the first thing I've got to do before I can proceed to that is I've got to decide the subject matter jurisdiction issue. And I'm wondering, in light of what you're just saying, is what you say is in fact true? Could somebody amend during that time frame if there has been a notice given, not just that there's a consideration to denying a trial, but to dismissing on grounds of lack of subject matter jurisdiction? Or by that, had the court committed itself, having identified a jurisdictional problem, to deciding that problem before anybody took one further step, to use the language of our cases?
The way I view it, and I think the way the jurisprudence views it, is that the request to file an amended petition, as Dowdy and Peabody indicate, is not sufficient. You actually have to file the amended petition. Without the actual amended petition to supplant the claim with respect to which there is no subject matter jurisdiction, then the habeas court must first, has no authority other than to dismiss the petition at that juncture. And Judge Newsom actually told Stonehouse, he said, look, I issued my motion to dismiss before I agreed to the scheduling order. So clearly, and I don't think this is a notice case, I don't think it matters, because the case law, counsel is apprised presumptively on notice of the case law, at least the relevant case law. So I do not believe that the court had subject matter, the court had to first deal with the subject matter jurisdiction. And I think what's important about, may I proceed,
Yeah,
Judge?
please go ahead.
And I think what's important is that Stonehouse, after all of this time, first posits a sentencing claim, and then when Newsom said, how could another sentence affect the sentence that implicates special parole, how could that do that? Stonehouse said, well, I have an ineffective assistance of counsel claim. Well, that ineffective assistance of counsel claim is really hinged on the sort of the legal infirmity of his view of the relationship between special parole and the petitioner serving before special parole goes into effect his prison term on another conviction. So he was raising once again an ineffective assistance of counsel claim, which is completely lacking in cognizability and over which the court had no jurisdiction. And I want to point out something else, that if we're just talking about the sentence, then petitioner can go to sentence review. I just don't understand this. It wasn't just that what petitioner was claiming in his first petition sort of was lacking in legal cognizability, but he didn't go to sentence review. If it has to do with the sentence and not the conviction, what was the petitioner doing in habeas? And that's another, so you're asking, Judge Sheldon is asking, well, Your Honors, I mean, what can the petitioner do? Well, he can file another habeas petition, or he can go to sentence review, Judge Sheldon.
Can you go to sentence review if there's been a negotiated plea?
That I don't know, probably not, but I'm not certain.
Well,
Judge,
that's what I don't think sentence review is available to him under these
okay,
circumstances.
fair enough. But I don't think that changes the fact that he could file another habeas. But the point is that's on him, or ultimately, if there's a time problem, he can do what every other petitioner has done ad nauseum, which is file a claim of ineffective assistance of counsel against Stonehouse. So, these claims are never ending, and there always is a way to address them. But I would argue that counsel cannot sort of overcome the hurdle of subject matter jurisdiction when the Judge Sheldon.
Same question that I asked to Attorney Fetterman up front. if we agree with you and find that it was proper to have dismissed this for lack of subject matter jurisdiction, is there anything intrinsic in this proceeding or in that result that would bar him from going back to habeas court, as was suggested by Judge Newsom, and filing a new petition?
I
Raising
don't.
the claim that he wanted to raise by amendment.
I don't know of that, Your Honor.
What does that mean? What does that mean?
What I mean is, I don't know of any
You-
barrier to that. I was thinking of what my friend here said about when custody terminates. And
Well,
I have a
that's-
memory in the record of Stonehouse saying that when he finishes serving his last period of imprisonment, I think it would be in November of 2021. But that's a guess based on an imperfect record. But I don't see any barrier to that. And I want to point out something else. I don't believe that under Gilchrist or under 2329, somehow the right to counsel supersedes subject matter jurisdiction. But as the reason I was pointing to all of what existed over the 8-month period and over the 5-week period, counsel had an ample opportunity to act as counsel in this case. It's not as if he didn't have an opportunity. And ultimately, then he comes to court, and all he has to proffer is a clearly a claim which is not cognizable on any level. And I'm not sure what Attorney Fetterman is talking about with regard to 2 other claims. But as I've said, the claims that he raised, as I really went to a great degree to sort of go into what special parole means and what his claim is actually founded upon. And it is completely frivolous. It's exactly what Gilchrist is talking about when it says that the whole point of 2329 is the ability, this is at 553, at 334 Connecticut 553, the whole point of 2329, which it shares with 2324, is the ability on the pleadings to get rid of a case like this, which is patently defective, which is completely frivolous. And it's on, it seems to me, if there's any onus, it's on that law firm and on Stonehouse for not coming across over this extended period of time and trying to figure out if there's any plausible claim. And what is going on here is really contrary to the law. And there's not one case, as far as I can tell, which somehow has taken the notion of the right to counsel and somehow read that as overcoming subject matter jurisdiction when there's only a motion to amend, not the amendment itself. Judge Elgo.
Counsel, would you enlighten to me as to what your understanding of curing the deficiencies? What are the parameters of that role, that work that is suggested here?
Well, I'm not, I think counsel really has to develop that. I mean, obviously, in this case, curing the deficiencies would perhaps look to a claim raised by the pro se petitioner and then raise a cognizable claim or hone that claim. But counsel didn't do that. He had an opportunity to do that, and he never did that in this case. And that's why this case is very different from other cases. Counsel was appointed. He had notice. In fact, he had notice of the motion to dismiss, 5 weeks. Judge Sheldon.
Are you suggesting, therefore, that this is somehow a waiver because counsel didn't act in timely fashion and he only sought at the hearing to do the very thing he could have and should have done 8 months before?
I would never say the word waiver, and I've never made that.
I thought that might be an interesting direction to go.
I'm not going to raise that. I haven't really investigated that. I think jurisdiction is really a sounder basis to go. I'm just responding.
Sounds like a new habeas to me. Sounds like a new habeas if waiver is the word you use.
Excuse me?
It sounds like a new habeas if waiver is the word that you use.
I'm not using the word waiver. And I don't want to get into that morass. But I'm mentioning counsel because in the end, this goes back to Peabody and Dowdy. And I don't think my friend here has really even addressed that jurisprudence, which I think really is the case which really specifically addresses it. Don't forget in Nelson, which counsel relied upon, that wasn't a subject matter jurisdiction case. And in that case, the court said, well, look, you never amended your petition. You're out of luck. You could have amended it. In this case, counsel moved to amend, and at least Peabody is very clear, and I think it's clearly analogous, and Dowdy is very clear, that the moving to amend is insufficient. You have to actually file the habeas claim, the new habeas, which is what they mean, what 2332 means, at least in this context, is you can file it as a matter of right, which means you don't have to ask anybody for it. You can just do it. And
Counsel, can you clarify for me in terms of the timing of the filing of, let's assume there was an amendment that was filed. It's a colorable claim. Does it make a difference if it was before or after the time in which the court scheduled the hearing on the motion to dismiss?
I don't think the scheduling order is controlling in any way.
So but I mean, not the scheduling order, but when the court sua sponte schedules a motion, a hearing on the motion to dismiss.
Yes.
Does it matter if the amendment is filed before the motion is scheduled, or if it comes in after? Is the court required?
Well,
would that result in have a different result?
My understand. Look, this area hasn't been completely explicated. I think it's been most specifically explicated in Peabody and Dowdy. And I think what they suggest very clearly is if counsel had amended the petition with a cognizable claim prior to the hearing, then the habeas court could not have dismissed the case based on subject matter jurisdiction, because clearly there would be an operable cognizable claim. And the claim over which everyone agreed was not cognizable and over which the court had no subject matter jurisdiction would have been replaced. But that wasn't done in this case. And he could have done it, and there was no barrier to him doing it, and he didn't have to ask the court to do it, as far as I could tell at any rate. And so, frankly, and then he comes back now, and he says, well, I want to amend it. Let's assume, for the sake of argument, that somehow the court had the ability within its discretion, which I don't think it did, actually. I've thought about this a fair amount, that the court had the discretion to allow the amendment. Well, how possibly could he have allowed the amendment when counsel was seeking to amend something with a claim which I think I demonstrated, and my friend here has not really responded in substance to, was not cognizable, was not a legally, it's a frivolous claim regarding subject matter jurisdiction, and you can't make it less frivolous by somehow saying that it's actually an ineffective assistance of counsel claim, which it's really premised on a faulty notion of subject matter jurisdiction. So then the query is, why would, if this all falls within the court's discretion, then it surely wouldn't have been an abuse of discretion to bar the amendment when it clearly was a claim which was not cognizable. And so it just seems very circular. You're dealing with really an empty vessel of a habeas claim, which is within which the petitioner has never put anything in of substance over which the court could act, frankly. So I just think the claim is just frivolous, and the court should just get rid of it on the basis of such a subject matter jurisdiction. And I don't think I have too many other arguments. I think I'm repeating myself.
All right. I see no further questions. Thank you, Attorney Brody. Attorney Fetterman.
Thank you, Your Honor. One thing I think I can agree with Attorney Brody on is we're not reviewing the best practices of habeas, and would it have been a lot more beneficial to all the parties had counsel filed an amended petition? Of course, and I cannot argue against that, but to say that that doesn't really resolve the issue because and I apologize because Attorney Brody's not on these cases. I have a handful that have been dismissed under 2329 and one particular in which counsel attempted to do just that, file an amended petition, and the same habeas court refused to accept the filing of the amended petition, even though there had not been a ruling on the motion to dismiss yet. I can't recall if there had even been a hearing on it yet, but the court had issued notice of the hearing. So I do think this case, whether Attorney Brody's correct that ultimately there will be no non-frivolous claims, still needs to address procedurally the boundaries of the habeas court's authority to dismiss petitions once counsel has been appointed. And here we do have, although we don't have an amended petition filed, we have a scheduling order entered into where counsel is saying, I will file an amended petition by November 2021. And I would be hard pressed to think that counsel would not be able to rely on that date in the scheduling order that Judge Sheldon?
Just this question, if his sentence is supposed to end, or his custody is supposed to end in November of 2021, who agreed to an order where the thing wouldn't have been amended, even as a necessary matter under the scheduling order, until he was out of custody?
Well,
What's that all about?
I'm not sure, and I would, I respect Attorney Brody's calculation that was the date custody would end. I don't have my own. I would defer to the record, and the reason in my reply that I didn't respond substantively to the arguments about whether or not those claims would be frivolous is because there's no information in the record as to what I would be unable to stand before this court and make an argument that either that is a colorable claim that should go forward or concede that that's a frivolous claim, because we only have the representations of Attorney Stone. I have no information on the sentences, the structure of the sentences, the dates of the sentences, so that I could stand before the court and opine whether or not he will be in custody should a new petition be filed, whether that claim could be a viable claim or could not.
But if I may follow up then, don't the rules specifically allow a lawyer to provide by way of description that which a claim might consist of, so that we don't have to worry about presenting evidence or a brief or something like that? And when the court is to consider whether or not there's good cause, for example, to dismiss, it can consider those unsworn statements of counsel, even though in other contexts we would not do that. Wouldn't you agree?
I would agree, and I argued that very point in my principal brief, that Attorney Stone standing before the court and saying, I think he has a colorable claim and I need to investigate it further, is such a representation of counsel that would...
But that's a trust me allegation. In other words, give me the chance. I'm sure I got something good here. But there's nothing specific. If he had gone so far as to give a description of that which he had, then we could take a look at that and make that determination. In a way, that's what Mr. Brody is suggesting. The best we've got is what he says. And what he says is something which runs right straight into the Farrer case, because the claim of ineffective assistance was failing to realize the defect that Farrer said was not a defect. Right? I mean, that's kind of what he's saying. So if you can live by the sword, you die by it. If you can consider the statements of counsel, then you can fairly ask, is that all the further you can go? And if you can't go any further, what's there left to rule on?
Well, I would ask the court to consider the corollary to counsel's statement, which was, I still need to investigate it. And yes, I, again, do not disagree with Attorney Brody that the habeas firm had the case for quite some time. And unfortunately, this is the situation Mr. Marshall now finds himself in. And with any of these cases, I always cite to the language of United States v. DeCoster, which is the focus is not on counsel's conduct, it's on the petitioner's constitutional rights. So again, irrespective of habeas counsel's ability to amend the petition, the focus for this court should really be, is Mr. Marshall being deprived of his right to pursue a petition for writ of habeas corpus because there's been a dismissal after counsel's been appointed? Certainly, Mr. Marshall himself can no longer file an amended petition on his own behalf. And we have a scheduling order entered into, which counsel should be able to rely on, that he has until November 2021 to file an amended petition. Otherwise, the scheduling order should not have been accepted by the court. But once that date was agreed to by counsel, and accepted by the court, theoretically has until November of 2021 to either have an amended petition or move to withdraw from representing Mr. Marshall. But Mr. Marshall's now, oh, Judge Alexander?
I just wrap up. Your time is up. Thank you.
Oh, thank you. So again, I would just stress that the issues that are present in this case, the operation of 2329 does go beyond the claims that were raised by Mr. Marshall specifically, and I think this is an area ripe for this court's guidance on the appropriate procedures for the habeas court.
All right. Thank you very much, counsel, and thank you for participating in this virtual hearing. We look forward to seeing you in our regular courtroom, and we're going to take this matter under advisement. So we will
Thank you so much.
recess until 3 o'clock. Thank you.
Thank you.